Hi, everyone. My name is Aubrey Weatherford with OMMS, and we're glad you're here to join us today. We've got Beth Ann Childs, who's going to speak on statutory filing requirements and deadlines. So hopefully we've got some new faces today, but if you have questions or anything, there's a Q&A button at the bottom of the screen, or you can always use the chat feature as well, and we will get those questions to Beth Ann and she can answer. So I'll let her take it away.
Thank you, Aubrey. My name is Beth Ann Childs, and I'm an attorney who focuses my practice on representing Oklahoma municipalities. I've been fortunate in that I've pretty well spent my entire career, almost 30 years, doing this. And right now, I represent the city of Bristow. I represent the town of Luther. I represent the town of Winona. I'm the prosecutor in Coweta, the prosecutor in Owasso, and then I do contract work for OMAG and also for several other cities. I'm completely passionate about municipal law. One thing that I will tell you about today's program is there is so much information that we really could have gone all day and probably into the evening. So what I tried to do was break this into manageable pieces and also give you some resources that you all can utilize. If you have any questions as we go through this, please be sure and notify Aubrey, and we'll do our best to get them answered. Let's see. And now I cannot get it to work. So, hey, Aubrey, you may have to help me get it turned. Okay, well, I'll go ahead and get started. Good, here she comes. There we go. Perfect. Okay, thank you. The first thing that I'm going to talk about is general elections for non-charter cities. One thing that I want to emphasize is that if you have a charter for your city, of course, those provisions are going to prevail. The other thing that I want to mention is it's critically important for you all to get your city or town attorney involved in these types of things. And, you know, I found it's very beneficial to communicate by email and just to make sure everybody is on the same page when it comes to these. But with the upcoming general election in April of this year, I felt like it was important to start with these particular requirements. By way of reminder, the first Tuesday in April, an odd numbered year, so that'll be 2021, is the date for municipal elections. Sometimes that process goes smoothly. Sometimes it's just a complete nightmare until the election itself, and then sometimes after that. So the filing period for candidates is the first Monday in February through the first Wednesday in February. The election resolution must be published in a newspaper of general circulation at least 10 days before the filing period. And that is really, really important, obviously. You all should have a template of the election resolution that you have utilized in the past, but I would encourage you, in fact, every year when I go through my various resolutions, be it for the Municipal Budget Act or if I'm working on an election every other year, I always pull out the statute, review it, make sure there isn't anything new that I need to be aware of. Newspapers of general circulation. That is a little bit of a tricky issue. Some of you may be very familiar with those requirements. If not, and you can use some guidance on that, the Oklahoma Municipal Attorneys Association has a website. It's called Raising the Bar, and I actually did a tip of the month on newspapers of general circulation. So if you want to go to that resource, or if you have any questions about it, feel free to email me and I'll send you that information. If there's no newspaper of general circulation, the notice must be posted, the election resolution itself must be posted by the first Monday in February through the first Wednesday in 5 different places in the municipality. For example, I represent the town of Winona. There is a newspaper, I guess, which could be considered general circulation in Hominy as well as Pawhuska. But just so everyone knows what's going on, and in the event that there was ever a challenge, I always try to ask my clerk to post it in 5 different places. Of course, one of those postings needs to take place at where you file your normal agendas. So if you're a belt and suspenders person like I am, you probably not only do the publication, but also the posting. Filing with the election board. The resolution must be filed with the election board at least 15 days before the filing period begins. And you must provide a map showing the corporate limits and the ward boundaries. That is something that sometimes is overlooked by municipalities, and with the compression and restrictions that have been implemented by the legislature with regard to annexations, it's not quite as big an issue as it used to. But probably a good tip would be to go ahead and find that map and make sure it's accurate, so that all you have to do is provide it to the election board. Of course, you want to be sure and keep track of the approval dates for the resolution with the public meeting. I'm going to take just a minute and talk about the Town Meeting Act for general elections. This wasn't something that I had dealt with. I was city attorney for about 12 and a half years for the city of Broken Arrow. And so I had to sort of retrain myself when it came to dealing with towns. The Town Meeting Act pertains to non-charter municipalities with fewer than 2,000 residents. It became effective in 2013. And what was interesting about this amendment was it became automatic unless the municipality opted out by ordinance. It replaced the county election board process with a town meeting. It allowed registered voters to nominate candidates for elected office and the voters present to elect the candidate. It's held at the same time as other municipal elections, like we previously discussed. Now, the process itself is a little bit different. The notice must be signed by a majority of the governing body members. The date, time, place, and agenda must be published in a newspaper of general circulation at least 2 days before. If there is no newspaper of general circulation, again, it must be posted in 5 different places. The notice must list the offices to be filled, including the number of officers to be elected. Registered voters nominate candidates for elected office, and the voters present elect the candidate, and voters sign a poll book. Now, I represent, like I mentioned, the town of Winona, and one of the things that they had done was they elected to stay with the county election board process. And some of the reasons that you might want to opt for the statutory process is a reduction in cost. But I do think that, and my feeling is that the town of Winona officials believe that continuation of utilizing the county election board brought some legitimacy to the process. Also, we've all been sitting in a bad meeting where things tend to get out of hand, out of control. So if you don't have access to law enforcement, or if you have kind of a funky process, then that might be a good way to do that. Okay, I have 2 questions. It should be contained in your ordinance. The other thing you might do is contact the election board, and because they typically have record of those. It says by ordinance, but and I'm trying to think, I went back and looked, and I actually found it in the Winona ordinances, but I would encourage you to go back and look at the communications with the election board. If you haven't done that, now would be a really good time to put that into the ordinances. No. Yes. You know, is it a good idea to utilize social media? Absolutely. Do you use that as the method of posting? I would not count that as one of the ways. Clearly, there are some opportunities for the legislature to continue to update rather, the use of technology, but there are still some folks that are paper people, and so super important to follow the statutory requirements. Okay, these are my helpful hints on general elections. I worked for a city manager one time. One of his phrases that he utilized frequently was measure twice, cut once. Great advice. Check the dates and then check them again and then check them again. Work with your county election board. Over the years, especially when I was in Broken Arrow, I was the interim city attorney in Bethany, and I had purposely developed a working relationship with the people of the county election board. They are wonderful people. And I found them to be in all my counties that I've dealt with. They're receptive. They don't want an election to be undone. They're a terrific resource. I would call them now, take them a tin of cookies, do whatever you need to do to recognize their efforts. And, you know, a lot of times they're super good about disseminating the information. Review all the documents carefully. Review the notices carefully. Use your city or town attorney and utilize a checklist. There may be some resources out there that you all have utilized in the past through the Clerks and Treasurers Association. I am huge on checklists. For a very, very short period of time, I did a medical malpractice defense, and hospitals, for example, have really gone to avoiding liability and problems by creating checklists and by doing things the same way every single time. So I always encourage my clients and my clerks and my treasurers. Also confer with your fellow clerks and treasurers. They can be a terrific resource. Okay, election dates, and I'm going to have to put this up on my hard copy because I am going blind. I copied and pasted this directly from the State Election Board website. I would encourage you to print this document out and keep it with you, because it tells you the dates that first of all, that the general election is. Of course, it appears to be darkened out on this one, but if you go to the State Election Board website and type in 2021 calendar, it'll show. Secondarily, it shows the other dates for the special election period, as well as the dates of when the resolutions have to be filed. There is a caveat, and that is there are times when you have to have the resolutions filed an additional period of time as a result of federal law. So that's why, again, it's so important for you to maintain contact with your county election board. I remember one time the city of Broken Arrow was going to run an election. It was a special election, and it was for extension of the vision tax for the city. Well, because they elected to place another matter on, it actually increased the time that the resolution had to be filed. And I think it was by 15 days, I can't remember. But the election board, as soon as they got notice of that, they disseminated it, and it really compressed our time frame to get the resolution approved. So my helpful hint to you is, or I think, this is just, you know, nothing, I can't point to any significant data about this, but the most common, at least in larger municipalities, for general obligation bond issues. It can also be used, the special election can also be used to fill vacancies. And there's some funky provisions about that, depending on when you have an elected official that either resigns or passes away or is no longer able to serve. So I'd encourage you to consult your city attorney about that. Amendments to the charter, that's a big one. Changing language for general obligation bond issues. So for example, if the bond language had referenced a particular project and you need it, the elected officials believe that it's prudent to either capture another project within the same category or something like that, then that's going to have to go back to a vote of the people. So you always want to be cognizant of that. Okay. Charter provisions on special elections. I am going to go ahead and discuss this briefly. I'm not going to go through the GO bonds because that's such a highly specialized field. If you're running an election for GOs, you want to be sure and have bond counsel actively involved in that, because they're gonna tell you what you need to do and how you need to do it. Like they typically proof the ballot, or your city or town attorney. So just be sure and be aware of those requirements. I want to talk a little bit about the charter provisions though, because they are a little bit funky sometimes. The Oklahoma Constitution addresses the framing and adoption of a charter. Broken Arrow was one of the largest, if not the largest, non-charter council manager form of government. And every once in a blue cheese moon, people would come in and say, okay, we want a charter. And when I explained the process to them with freeholders and individuals that aren't the council basically making the decision as to what was contained in the charter, that tended to be the end of those discussions. But you know, if your city or town is interested in having a charter rather than following the statutory framework, this is the process that you go through to do that. So if you've got a proposed charter that has been completed by freeholders, it has to be published in a newspaper of general circulation for at least 21 days if in a daily paper, or 3 consecutive issues if in a weekly paper. First publication must be made within 20 days after the completion of the charter, and within 30 days and not earlier than after the publication. So the time frames are really compressed, and so it's super important that you're paying attention to those. The Oklahoma Constitution also addresses amendments to the charter. It may be amended by proposal submitted to the Board of Trustees or the council. Has to obviously be approved by the electors at a general or special election and ratified by a majority of the qualified electors voted therein. So, and then it goes to the governor after that. Okay, state statutory provisions are a little bit confusing, and I'll explain to you why I'm mentioning these in just a second. Within 20 days after receipt of the proposed charter from the Board of Freeholders, the governing body shall publish the proposed charter and an announcement of the date for the charter election in a newspaper of general circulation within the municipality once per week for 3 consecutive weeks. The date for the charter election shall not be less than 20 days, no more than 30 days after the last publication. Okay, we had a situation in one of the cities that I represented, and the amendments to the charter did not come from the Board of Freeholders. They actually came from the City Council. So their previous attorney and I had lots and lots of discussions about, okay, well, there were no freeholders, the language is specific. Do we have to do this within 20 days? Do we have to publish it within 20 days? Because there was no receipt from the Board of Freeholders, or do we just count the days out, 20 to 30, after running it for 3 consecutive weeks? And we ultimately decided that the 20 days for the Board of Freeholders didn't apply. So we went with 3 consecutive weeks. Well, we got a love note from the general counsel of the governor who said, you didn't publish this within 20 days, and so I'm not going to sign off on the charter language. Well, I ended up writing a long letter, and it was submitted, and he changed his mind, and they did that. But I say that only to caution you that it seems as if somebody might try to raise an argument that it's got to be published within 20 days after it's received from the Board of Freeholders. And then you talk about the 3 weeks and the 20 days and the 30 days. You just really have to be thoughtful about mapping those time frames out. You know, I remember when I was working with the clerk and at this client, we actually created a paper calendar and circled and colored just to make sure there were no missteps. So this particular section talks about amendments to the charter. One way that it can be done is by an initiative petition. That's something that happens sometimes, but if you're not familiar with the initiative petition and referendum process, I would encourage you to at least familiarize yourself with it. So if someone comes trouncing in and they hand you something that says initiative petition or referendum, you need to probably immediately notify the mayor, the city manager or town administrator if you have one, and the attorney, because there are some pretty limiting timeframes. So you want to make sure that information gets to them as soon as possible. The special election can also be handled by resolution of the governing body. You've got to follow the same statutory requirements that we visited about before in order to get that done. Now, I'm going to take just a second and I'm going to go over some really important references. One thing that, and I found this picture online, it's not exactly what I'm looking for, but I had a long time administrative assistant. And back in the day when she first started, there weren't computer programs. There really, I mean, it was mainly typewriters, things like that. And they had a wheel, somewhat like this, so that they could calculate the days. This is such a great belt and suspenders approach. If you don't have one, I would encourage you to get one. I still use one. I just couldn't find it when I was preparing this presentation, but you know, it's such a great way to double check. I mean, all the technology in the world is great, but it's important to have additional resources that can assist you in calculating the days, especially if you're going backwards when you're talking about a window of time between publication and notice and when an election or some other action has to take place. Okay, this is the very best resource of all, the Handbook for City and Town Officials. OML actually sells these. If you don't have one, I would, as soon as we complete this, I would encourage you to call OML and order one. It is the best thing. I mean, I called it the magic book for years because it's got so many things in there. It really is almost magical. But like I said, if you don't have one of these, get one as soon as possible. Great, great, great information. Now I'm going to talk about checklists. I mentioned to you previously that I'm a huge fan of these. And I'm going to start with the Municipal Budget Act. This was the very first one of these that I did for OAMA. And it's on the Raising the Bar website. I love these, and so every fiscal year what I do is I go back, I review the statute, and I make sure everything is correct on my checklist. And then as I'm going through the process, I provide one to my clerk or treasurer, and then we just work through the process. So first thing I have on this one is important deadlines. Even though we got to get through the election first, the municipal general election, it's always a really good idea to start thinking about following the Municipal Budget Act. Before June 1st, the budget's got to be prepared by the CEO and presented to the governing body. Before June 16th, you've got to have the public hearing. You've got to publish the notice of the date, time, and place of the hearing and the budget summary at least 5 days before the public hearing, published on the municipal website and in a newspaper of general circulation. Obviously, you've got to have copies of the budget available with the municipal clerk. Before June 24th, you adopt the budget by resolution. July 1st is obviously the beginning of the fiscal year, and July 30th, the adopted budget has to be transmitted to the state auditor. The one actually on the OAMA website has the statutory references in that. And so, like I said, I would encourage you to go look at that website and you can download these. If you can't find it or don't have access to it, if you'll send me an email, I'll make sure you get it. It's a good resource. Adoption of ordinances checklists. You know, I have a theory. Mad people file lawsuits. And because we're in the business of making people mad, either because we approved a project or we didn't approve a project, or because we didn't do what we wanted them to do, or because of personalities, or because they've been trying to play gotcha, you just unfortunately are held to a super high standard. And I've seen lots and lots of things unraveled as a result of ordinance that weren't properly adopted or published. Clearly, an ordinance must be adopted at a public meeting. They must be adopted by a majority of all members of the City Council or the Board of Trustees. They must contain only one subject, and the subject of the ordinance must be expressed in the title. Unless a later date is specified, the ordinance goes into effect 30 days after passage. Now, if it has an emergency clause, it goes into effect immediately. The emergency clause must be for the immediate preservation of peace, health, or safety. Now, emergency clauses have been the subject of much debate among elected officials and attorneys. And one of the things that I've had clients say is, okay, well, this really was an emergency. This has been bumping around out there. And I always remind my clients that if they don't adopt or approve the emergency clause, then they have to publish the ordinance in total. And so if you have a particularly verbose city or town attorney who writes and writes and writes and writes, and you've got a 20-page ordinance, that is going to be super duper expensive for the city or the town. And so that's one thing. The other thing is, if you've got projects or you've got things that are moving along, and you just need to be prepared to justify for the elected officials why an emergency declaration is necessary. Like I mentioned previously, you've got to have a separate section saying the reasons why it's necessary. It's got to be by separate vote. I've seen this happen a couple of times to where they try to do it all in one motion. So don't forget, it's moved to adopt ordinance number blah, blah, blah. And then if it passes, then the emergency move to approve the emergency clause. And it's got to be approved by 3/4 of all the members of the governing body. If the emergency clause is not approved, that's okay. That just means that it reverts back to the 30 days. Okay, no ordinance having a subject other than the appropriation of money will be enforced unless it is published in full within 15 days of passage. Now, some of you all handle this like a rock star, like rock stars. So you're supposed to have an ordinance book with the ordinances in there. Many of you all that I have worked with over the years are super good about getting the publication back, and you put everything in the ordinance book. So if you ever get a challenge to the ordinance, you have all that done, which is great. Ordinances passed with an emergency clause may be published by title only. If you look at any of the agendas that I do, I'm sure that my elected officials just want to flood me. Actually, probably more my clerks, because I'm very, very detailed in the title. And not only do I say, okay, these are the sections of the code that are being amended, but I also try to provide an explanation as to what the revisions are actually meant to accomplish. And so sometimes I'll have a really, really long title, but it's got to be sufficient so that a person of understanding, an ordinary understanding and sensibility could understand it. So some of it's got legal jargon in there, but if you can get the basics as opposed to really, really small titles, then I just think you're going to survive a challenge so much easier if you've got an emergency clause. As I'm sure you know, compilation of codes or regulations, traffic, building, plumbing, electric, may be published by title with a summary of their contents. So then, of course, I also mentioned just on that particular checklist the statement that's required to go along with that. And there's the section about the ordinance book. So just make sure you maintain that. And I have had issues over the years where we went back and now we can't find ordinances that were actually approved. So as much as you can keep all that together, it's very helpful. Okay, codification. Apparently I did that over, so I'm going to skip ahead. All right. If you prosecute penal ordinances and it's more, you want to charge more than I think $50, your ordinances have to be codified. But you really need to have them codified anyway, just because it provides good notice for your residents. And it can be as simple as keeping them in a notebook, keeping it updated, or it can be as complicated, not complicated, but comprehensive as hiring Municode or some of these others to keep track of it all. The nice thing about using Municode or some of the, and this isn't a commercial for Municode, it's just the one that I'm most familiar with, is that you provide your residents with online access. And so that's something that can be super helpful in terms of notification. Also, let's say you have a police officer in the field, they don't obviously have the codes memorized, although they do a lot of them. They can just go in and do a general search and pull up the ordinance. So it's really a good way. It is a little bit expensive, but I try to encourage my clients to be thoughtful about that. I have a saying, this much work saves this much work or this much work. And so I found in my almost 30 years of practice that there's a lot of value in spending the money on the front end. I think it saves you a lot of grief in the long run, particularly because they keep a bank of those things. So let's say you end up having an ordinance and you can't locate it, you should be able to go back to them and hopefully they have put a copy of it up in the cloud. 3 copies of code have to be kept in the office of the municipal clerk. Make sure you do that. And the clerk has to be able to sell it at a reasonable price. Although, like I said, most people just go online for those. Penal ordinances must be compiled once every 10 years. That is hugely important. And there have been a few cities or a few towns that have been sued over this. So just make sure that you have that every 10 years docketed. If you are with a code company, a lot of times what they'll do is they'll do the supplements on a quarterly basis. But for my smaller towns where we have the notebook, I'll do that every 2 years. You also need to have a resolution passed, and then the resolution has to be filed. They also have to be filed with the law library. So let's talk about that for a second. Whether you're talking about the 10-year time frame or the every 2 years, you've got to have the Board of Trustees or the council adopt or approve a resolution approving it. Once that's done, you got to file it in the office of the county clerk in each county in which the municipality is located. So for example, if you're in Broken Arrow, you would need to file it in, oh, somebody just raised their hand, awesome. In Tulsa and Wagner County, just for example. One copy and the supplements has to be filed in the county law library. And I can't emphasize the importance of that enough. A lot of times what I will do is I will prepare a written receipt and ask the librarian or the clerk, whoever's responsible for maintaining the law library, sign it, date it, get it in. I have seen places where that really became an issue and the municipality may have had to abandon ship on a particular issue because the code wasn't located in the library. So what I used to do, and actually I still do, is I maintain a compilation, an executed copy, file stamp copy of those resolutions with my information so that in any given moment in time I can lay my hands on it if I need to. Let's see. Okay, planning and zoning. And I'm wondering, I'm going to just try something here, and I'm not terrific with technology. In fact, my daughter had to help me, my teenage daughter had to help me with this PowerPoint. Have I got a question? Oh, okay. Am I? Oh, good. Okay. Oh, technology. Oh, okay. All right. So I'm going to try a little. Hey, Christine Dawkins has raised her hand. So I'm gonna try something here as my big virtual experience. How many of you handle publications for Planning and Zoning Committee? 3. Oh, 5. I'm kind of curious. So yeah, if you don't mind raising your hand, I'm gonna see how many. Okay, now, how many of you, the planning department or other staff handles it? If you'll raise your hand. Yeah, it's okay. Thank you for letting me know. It's such an interesting dynamic, and whatever that process is, it's important that you all work together to make sure that you're getting the best system possible. And, you know, if it can be redundant, even better. This is another one of my crazy checklists that I put on there. I'm in the process of updating some more. So, or of creating some more. So stay tuned. I promise every year I'll go through and double check the statutes. But if you are enforcing, if your city or town is enforcing a zoning code, you have to have a planning commission and you have to have a board of adjustment. You don't have either one of those things, you are without the ability to do that, to enforce zoning regulations. So keep that in mind. Secondarily, I know it is super challenging to find people, residents that are willing to serve on these commissions, particularly in the smaller towns. That's why it's so important for you all and your elected officials, I guess more importantly, your elected officials, to be advocates of your city or town and try to keep in mind people that would make good public servants. I think too many times we just kind of sit on our hands and we don't aggressively recruit people or think of people that would be really good And sometimes if you can get them involved at the Planning Commission or Board of Adjustment level, they'll find that they like helping the city and they consider it to be their civic service. And so that's a great way to introduce future board members or council members to the process. Okay, comprehensive plan. A couple of years ago, there was a 10th Circuit opinion that had to do with a comprehensive plan. It wasn't, I don't believe it was over the state of Oklahoma, but fortunately they were able to go back and rectify the publication of that. But keep in mind that comprehensive plan is something that's really, really important to the development of your city. And so if you don't have a comp plan, you probably need to, depending on your size, you need to start being thoughtful about what that might look like and how you would do that. Public hearings, unless otherwise provided by charter or in cities in excess of 200,000, municipalities are required to hold a public hearing in advance of making changes to district regulations. And then, of course, it talks just a little bit about changing the district boundaries, which of course would be annexations. Parties in interest and citizens shall have an opportunity to be heard at a public hearing before any district regulation or boundary becomes effective. The commission makes a preliminary report and holds public hearings, and then the governing body can't hold the public hearing or take action until it's reviewed the final report of the Planning Commission. So, and sometimes elected officials, they're not really in love with allowing members of the public to comment, but you know, that's what the statute says. And so, and also transparency. I've found over the years that if you give people a reasonable opportunity to express their opinions and be heard, that really does ward off a lot of lawsuits. Now, I'm not saying that you make it, as David Weatherford always says, open mic night, you know, where they can get up there and just blather on forever. But giving them a voice does matter. And so I would recommend that you update your elected officials, particularly if they're new, as to the statutory requirements. Aubrey, do you want to ask me a question? Okay. All right, notice requirements. Notice of the public hearing must be published in a newspaper of general circulation at least 14 days in advance of the public hearing. Notice must include a map of the area to be affected, which shows, it's got to show street names, numbers, streams, other significant landmarks. If the zoning change requires permits of treatment facilities, multiple family facilities, transitional living facilities, halfway houses, or housing facilities using medical or non-medical detoxification, then written notice must be 30 days. So this is where that checklist can be helpful. Might be good to break that down into pieces, but if you have somebody coming in that wants to do, you know, transitional, multifamily, medical, make sure you make a note that it's got to be 30 days. Contents of the notice are set forth in state statute. Notice can also be given by posting on the affected property at least 20 days before the date of the hearing. So, in addition to the notice requirements provided above, there are certain times when you are required to post a sign. I would double check that every single time because, and of course, there are additional requirements as to what the sign has to say, how it's managed, when it's going to go to the hearing, that type of thing. Okay. If the proposed zoning change does not pertain to the items set forth in B, the notice must be given 20 days in advance of the public hearing by mailing written notice to owners of the lots within a 300-foot radius of the change. I actually keep a template of the notices. That way I know what they're going to say. And the notice really should say public hearing before the Planning Commission, recommendation by the Planning Commission, and then the date, time, place of the City Council or Board of Trustees meeting. So I would keep that in mind. Okay, going back to our magic book. This is obviously cut off, but here, I'll hold it up for you. And you like Vanna White in the magic handbook. If you go towards the end of the book, you will see a page like this that was not cut off. This talks about the cities and town publications, citations, the number of times it should be published, where it should be published, and when. This is by no means an inclusive list. Oh dear, sorry. Okay, technical error. But I would like to talk about some of those that are in here. It talks about notice of the town meetings, the publication of ordinance, budget, like we discussed before, municipal, well, does talk a little bit about that, disposition of property. If you're a chief of police, that's something that some people don't really realize. If you're a chief of police and your property room is full to the gills, you can't just go in there and start getting rid of stuff. You need to encourage your chief to, now if it's no longer needed for evidence, that's something else and it's contraband. But if it's property that hasn't been claimed, be it like power tools or cash or anything like that, cash of course is very, weapons, then the chief has a statutory process that he has to follow, including publication. Let's see, notice of desire for sale or lease of a public utility. I did want to mention that because that's a big issue. Sometimes, you know, I'm sure you've heard of various entities, public entities declaring property surplus and then selling it. The word utility is defined pretty broadly. In fact, that there was some language in a case that talked about parklands, and the court found that that was actually a utility, which would have required a vote of the people to transfer it. So sometimes you'll look at like parcel switches, sometimes you'll have elected officials that are interested in providing land for maybe foreign economic development activities, something like that. You just need to be super careful about that and consult the city attorney, city or town attorney. The other thing is, if it was purchased with general obligation bonds, that is really gonna, unless those bonds are legally defeased, that's something you need to be super duper careful about. Nuisance abatement actions, there are some pretty significant restrictions in terms of notifications, and so make sure you're up to date and familiar with those. Fortunately, with everybody being home, it seems to have been a little bit less of an issue, at least in the clients that I deal with. But I did have a situation, it wasn't a publication, it had to do with notification, but we wanted to demolish a building, and so we followed the process. It wasn't the like lawsuit process, but it was through this. Well, we notified somebody from, I think it was the treasurer's records, but it should have been the clerk's records. In any event, it turned it into a gigantic issue because we huffed and we puffed and we blew a house down. And so then we had to go back and rectify that. So especially when it comes to nuisance abatement, make sure that you're carefully following the deadlines. Notice of intent to vacate part of a plat. That's something that also has to be done in accordance. In this day and age, the mortgage companies are super particular about loaning money. And so it's going to be really, really important if you get somebody coming in and they're wanting to close an active easement and they want to do it through an ordinance, and then you go through the foreclosure process. Consult with your city or town attorney, but make sure that everybody realizes and is familiar with the provisions so that nothing goes awry. Annexation, not really something that's used all that frequently now. Zoning regulations and close or vacation of public ways. So this is, again, not an all-inclusive chart, but it is a good little reference. So hopefully you'll find that useful. There's the second page. And I actually finished, I guess, about 7 minutes ahead of schedule, amazingly. I tried to, I guess I talk really quickly as well. Oh, good. Are you bringing me questions? Super. Okay, here we go. Oh, and that's me. So I'll just go ahead and do a little plug for the guy that took that picture. Curtis Sprague is a former police officer, and he has a business in, so if you need a picture where they make you look good, call Curtis. Yes, I believe that it can maybe. Why don't you email that? I would probably refer that question to your city or town attorney. It is possible, I think. So it's a big fat qualified. Very common. Absolutely. Oh, I did not put my, can you post something out there with my email address on there? Okay. Aubrey will send out my email address. And yes, I actually, if you're going to do that, I actually have Word versions of all the pleadings, or not pleadings, of the information that you need to do that. So I'm happy to send that, and you can send it to your city or town attorney, and hopefully they won't grade me too harshly. Yes, all you have to do is go to the Raising the Bar website, and I'll have Aubrey put a link on there for that. And so there are the checklists. Those are the ones that are on the Raising the Bar website. This book right here, you can order it from OML, and it has the publication. But I use this book, as you can tell. I've spilled coffee on it. I ran over it with my Beetle. I take it with me everywhere. I would sleep with it if my husband would let me, but. Okay. Good. Okay. Well, I'm sorry that I finished a few minutes early and then I'm not getting you more questions, but it's lots and lots of material to cover, and hopefully these resources will help you. And so thank you for having me. I really appreciate it.